fairness you attempt to impugn.
I didn't say that, and I think the court's trying to attempt, in a way that I think is unfair, to say, well, how can you get a fair trial on one count and not on others? I'm not saying that. What I'm saying is that, and the case law is clear on that. The case of People versus Brown, there was multiple counts in which the defendant was acquitted on some, there were hung juries on others, and there were convictions on others, and the court stated that, the court, I believe it was the Court of Appeals, stated that even though there had been some acquittals, we're not going to go into what went on in the jury room as to why that happened. We're going to say that when a person makes an emphatic statement before the case is concluded, I think in that case the statement was, why do we have to do this? We already know what's going to happen. We think the person's guilty. That's enough, and that there wasn't a fair trial. And the mere fact that the person was acquitted on some counts, and may have been hung juries on some counts, and that even that juror may have gone along with those verdicts is not enough, and I cited that in the brief. And I think that the court, you can't bifurcate the trial. Who knows what reasoning went on? And the court well knows that Evidence Code Section 1150 in the law of the state of California talks about the fact that we cannot go into the subjective thought processes that went on inside the jury room deliberation in each juror's mind.
But the fact of a not guilty verdict is not going into the subjective thought process. It's a fact that is readily ascertainable by reference to the file without the need to speculate.
Except that People versus Brown, I feel, dealt with that issue explicitly when they said, and I discussed that in our brief and cited it to the court.
I've read the Brown case, if that's what your reference is to.
The court clearly, in no uncertain language, expressed the fact that that wasn't enough to surmount the presumption of prejudice because of the statements that were made. In that case, there was an offending juror who voted for acquittal on 8 counts. And the court said that still wasn't enough. But when there is an expression of prejudice, whether it be as to 1 count or all counts or partial counts, that's prejudice. There's an expression of guilt prior to the time. And I think
of course, the question is there prejudice?
Well, the question is, first of all, no. The question is if there is a violation of the court's orders, violations of the court's instructions, and a violation of the law as stated by the courts of the state of California, a presumption of prejudice automatically is presented. Then the prosecution has to rebut that presumption. I discussed the case of People versus Brown specifically because that was a case in which the court addressed the very issue the court just raised, in which obviously somebody in that case had addressed the fact that here he got acquitted on 8 counts. That shows that these jurors weren't prejudiced. And the Court of Appeals there said we're not going to go into what kind of trading may have gone in the jury room, what kind of negotiations may have gone on, even what the thought process of people are. When somebody makes a statement prior to deliberations beginning that I think the person's guilty and expresses that statement, that's prejudicial. And in that case, they reversed and granted a new trial. And that was a case where the statement was made, I think, fairly emphatically at the beginning of the trial. Or somewhere, no, take it back, before argument was concluded.
All right. We'll reserve the rest of your remarks then for rebuttal, and I'll hear from the people by way of anything they wish to add in addition to what they filed in their written papers and anything to which they wish to respond to by way of what's been said this morning.
I'll be very brief, Your Honor. I think that the alleged existence of prejudgment or bias or improper opinion in this case, as well as certain asserted facts in the affidavits filed by the defense, have been controverted by the affidavits filed by the people, and also the logic of that is expressed in our brief, so I won't say anything further about that. I would point out that our affidavits do show that they do demonstrate some bias on the part of those alternate jurors responsible for the assertions made in the defense motion as to the issue of formation of opinions and so forth. And certainly the affidavit that we have presented of one of the alternate jurors does show that the alternate jurors themselves who have presented affidavits on behalf of the defense themselves engaged in formation of opinions and basically discussions prior to the case being submitted to them for jury deliberation. Certainly they never said anything about having biased jurors on the panel during the trial at an early place in time here. In addition, I would point out that the allegation relating to a formation of an opinion of guilt has been controverted by the affidavits we have filed, and certainly that is not the same as the situation in the Brown case, where it talks about a firm and fixed opinion of guilt having previously been in existence prior to the deliberations. That is not the factual situation that we have there. So with that in mind, I would just like to say that I think in light of a 2-year trial, common sense tells us that it is just not consistent with human nature to expect jurors to remain totally free from expression or from emotions or from making remarks. They cannot be totally isolated from being able to live as human beings, since they are not human robots or computers who are supposed to be boxed up and brought into court every day. That is just something you cannot expect to exist in this situation. And I think that the isolated remarks that allegedly were made and seized upon by the defense do not translate into biased opinions or fixed premature discussions of the evidence or formations of guilt. And I think that is well shown by the affidavits and by what Your Honor has observed occurring in this case throughout its long tenure here in this building. And based on that, I'll submit it on our written brief, Your Honor.
You may respond briefly, Mr. Chaliff.
Thank you. Just a few points. I know it was a long trial. I was here too. I was here every day, and in fact, I was here in relation to this case longer than the Attorney General, so I know the length of the time it took this case, and I know the arduous nature of it. I think the question becomes one of if, in fact, statements were made and expressions of guilt or innocence or expressions about jurors' feelings were made in relation to the evidence, completely contrary to the court's own instructions that were given every week, at least, I think, on every Thursday when we concluded on Thursday or Friday when we concluded for the weekend, and at other times during the trial more so, that there isn't an exception just because the trial took a long time. There isn't an exception that jurors cannot express their opinion unless the trial takes more than 3 months or something like that. I think the law is what the law is, and the cases are fairly clear. The second point is that there's no question that the incident with the friend occurred. The statement was made. It's been reported not only by the jurors in the affidavits we filed, but even the counter affidavits filed by the prosecution admit that that the statement was at least told from one juror to another, and the only way it could have gotten from that juror to the other people was a repetition of that story. And the point about the murder trial, or whatever the other trial that was going on, in the affidavit of the juror who says she didn't really know much about what happened because she didn't want to find out, she's quoted on page 2 saying that I never went in that court, and that I did not and still do not know the details about his case, that I tried to avoid hearing any facts about my nephew's case. And it turns out it was a case where he wasn't the killer. And it was a case where the other person was there. The court will refer to the file that I've cited in the new affidavit that was filed. And it was exactly what the affidavit stated reportedly was told. And I think that clearly shows that there was some statement made about this nephew's case, and that the denial on the part of the juror that she made it, when the facts seemed to support the fact that these alternate jurors found out somehow about the facts in that other case. And they didn't even know the name of the person because they couldn't put it in their affidavits. And it's clear that those statements were made. And I know that this court is hesitant, and I'm sure any court would be hesitant to overturn a trial that took as long as it did, and everybody devoted as much time as they did to it. But the law is the law, and the law is clear, I think. And it'd be easy for this court to just say, well, I'm only believe the affidavits of the prosecution and not believe the ones of the defense for whatever reason. The prosecution is, again, it's saying that those affidavits were to attack them for bias. I assume there's also a bias on the part of the jurors who came to the conclusion they did after the amount of time they were locked up to not have to have anybody go through that again. But I think that if the court looks at all of it, compares all the facts, and sees that there were facts that weren't denied, that these incidents did occur. And I think then we're bound by the law. Submitted.
Submitted?
Yes, Your Honor.
All right. Court will note its reliance, of course, on the provisions of Penal Code Sections 1181, Subdivisions 1 and 2, and Evidence Code Section 1150, and the case law interpreting those sections. First, it should be noted that, as established by the Linhart and Scott cases cited in the papers, affidavits are, in fact, the proper procedure, despite the fact that this process of going into what the jurors did does, in a sense, strike at the integrity of the jury system and tends to add to the ordeal of jury service by placing the jurors on trial themselves. It still is permissible to exhume the concluded jury deliberations in an attempt by the losing party to attack an unfavorable jury verdict. That's what we have here. We have counter affidavits filed by the people which are in conflict, and the court's obligation is to resolve the conflict in the affidavits. First, I should make clear that it's established when all the affidavits are considered that whatever transpired, there was clearly no withholding of information by any juror during the jury selection voir dire process. Any incident or possible incident, if in fact it occurred after the testimony in the case had begun. Now, I should note that a portion of what's tendered by both the defense and by the prosecution in its respective affidavits involves inadmissible material to the extent that affidavits get into the juror's subjective mental process, which is not permitted under Evidence Code Section 1150. And to that extent, of course, the court is, as it must, disregarding the portions which are inadmissible. With regard to the various points made by the defense, I would note that the indication of a dream by one of the jurors that Mr. Bono had been found not guilty, and then a statement by the juror who allegedly had the dream that that's not the way I want it because I feel that he's guilty, that has been contradicted by the juror in the affidavit that she herself has filed through the prosecution. So that is contradicted. I would indicate the following, that I am, in resolving these various conflicts, relying in part, as I feel I properly should, on the affidavits filed by the people indicating a certain bias on the part of two of the, or three of the alternates who were the subject of the defendant's affidavits. In fact, the affidavit of one of the other alternates filed by the people establishes clearly some prejudgment, some bias, some annoyance at the 12 sworn jurors for the action of those jurors in returning verdicts of guilty. And without going through in detail the various affidavits, I think it's quite clear that not only are the three alternate jurors for whom affidavits were filed by the defense contradicted by the prosecution's affidavits, but also there's a clear indication of bias on the part of the alternates, in effect a desire to impugn the verdict of the 12 jurors for whatever reason. And I would note that all of the affidavits filed by the defense come from alternates, with one exception which I will deal with separately, and that involves the question of any possibility of a discussion by the jurors of Mr. Bono not having testified. So I do find that as to the alleged dream, that incident never took place. With regard to the juror who stated that in the defense affidavit, there's an indication that one juror stated that she knew that Mr. Bono was guilty because the other juror said her friend had been picked up by a man whose description matched Mr. Bono's, and the friend got away. I would note parenthetically that this alleged incident doesn't involve two persons. It does include a van. It's markedly dissimilar from anything that we heard in the trial, except to indicate, as I did earlier, that there were numerous reports of sightings and missightings of the defendants to the point where I have to regard the possibility of prejudice is certainly being rebutted and by the state of the record and being quite remote by way of any possibility. Furthermore, that juror who says that she heard about this incident from the other juror denies ever saying that she therefore knew that Mr. Bono was guilty, and also states that this question was never discussed in the jury room. I would also note that the juror who allegedly was told this by her friends did indicate that this was unimportant. It was after the testimony had begun. It was not discussed in deliberations. And I would note, as the people cite in the Vernon and Spain cases, that it is not realistic to expect that jurors, especially on a lengthy case, are going to be totally isolated from hearing anything. The only way to have ensured that, I suppose, would have been to sequester the jury for 2 years and 2 days instead of for the 4 weeks. And I think the impossibility of that is evident. The United States Supreme Court noted just a few months ago in Russian versus Spain, quote, "We have previously stated that the Constitution does not require a new trial every time a juror has been placed in a potentially compromising situation, because it is virtually impossible to shield jurors from every contact or influence that might theoretically affect their vote." And the Vernon case, also cited by the people, indicates that the granting of a new trial is not required because of such remarks made during trial to jurors or in their hearing by strangers to the litigation, where neither the successful party nor the jurors were at fault, unless such remarks probably influenced the verdict. And I find beyond a reasonable doubt that they did not probably or even possibly affect the verdict. With reference to the jurors having stated that she had a relative on trial for murder, again, when you look at the counter affidavit filed by that juror, all that she said was, and I believe this, that she felt that Mr. Bono was guilty under the law upon the evidence having shown that whether or not he personally strangled all the victims, that he actually murdered some, and he was involved in all of the abductions and counts. And frankly, this determination by the jurors is certainly consistent with the evidence and does permit a guilty verdict to be rendered regardless of whether the jurors were ultimately satisfied as to who did the actual strangling on any particular count, as between Bono and Bianchi, as long as both were active participants who physically aided and abetted in the act. And the juror in question also denies ever having said that she thought that Mr. Bono would be guilty just because he knew about the offense and took no steps to stop it. Also denied by that juror is any statement that she knew Mr. Bono was guilty but said the prosecution couldn't prove